Good morning.
Good morning.
Hi. I think it's just going to be the three of us today.
Get out of here.
I'm serious. You'll see. I didn't send out a reminder. I want to see if if people got in the rhythm.
All right. Well, you know me. Whatever you're on, I'm on. Can I ask you something?
Yes.
With ESA, okay, if it's a two-family and the landlord lives there, can he deny a pet? Or is it still kind of dicey?
It's dicey if he's using you because you come with the law.
Right.
So he can if he does it on his own without an agent.
Gotcha. That's what I thought.
Yeah.
I was
If
kind of
you're
blank.
involved,
Then no. It's
yeah.
gotta, and don't you I feel like that whole rule is just so weird.
Same thing, like if like let's say a single woman living in a two-family house, like living in one unit, then she can pick who she wants in the second floor, but not if she's using an agent. Or vice versa, if it's a guy, whatever.
Okay.
You can't discriminate against somebody if they're using a realtor.
Okay.
I always say this to my clients, I come with the law. You want to do something, you can't use me. So that's just how it works.
Well, that's okay. That's a good way of putting it. All right. That's fine.
You want to do it the proper way where I guide you to make sure you don't get a lawsuit. I mean, nothing is guaranteed, but I at least will guide you the right steps. Then I'm here.
Okay.
So we'll see how many people join us today.
Okay.
It's Charles. I was just thinking
Charles.
with the dog. Hi, with the dog, isn't it? If they have a service dog, then it is permitted, right?
Yeah, they can't deny service dog.
Right.
But
Right.
again,
They can't
for example, if they have a two-family home and the owner lives on the first floor and they're highly allergic to, right? So it's really case by case, right? At that point, you're going to need attorneys because if somebody's highly allergic to dogs, whether they are a service dog or not, if the owner of the property is severely allergic, how can they allow somebody else?
Gotcha.
Right.
Which office are you with, Charles?
KW. Rob's friend. I'm Rob's friend.
Really?
Yeah.
Hi. Okay. I was like, I didn't recognize your name, so welcome.
Yeah, no, I was with Rob for like 10 years. We had a new homes division at one point, so he told me to listen in if I wanted to.
Guys, should we tell him now or should we wait? Because once
I already know. I already know.
Okay. Well, welcome.
Thank you.
We'll just start in another minute or two.
Okay.
I was like, depending how many people join, I was going to go over not the rental compliance because I didn't have a lot of people register for today. So depending who comes in, I guess I'll allow you guys to vote if you wanted to go through the rental compliance or on the new document. So let's see how many people join. We'll just give them a minute.
Okay.
Hi, Fran. I could not change the slide. So when I get to it, just remind me to change the word and I'll let them know.
I know. I struggled with that one slide. I was like, and Caitlin was trying to help me. She says, it's got to be a picture. You must have done it as a photo that you can't change it. And I'm like, I could redo the whole slide, but if we can,
We'll just correct it.
Yeah.
So just as a side note, I have several questions into NJAR regarding, commission and how to handle certain circumstances, with the SEPA and the NAR settlement, and they're evading me. So it's kind of interesting that I've got pinpointed specific questions, but they kind of send me, documentation, which I've already read, and I've been on all their Zoom calls and everything. It's just interesting that they wouldn't want to get right back to me with answers. So I don't know if anybody else is tried
Yeah,
to reach out to NJAR with specific questions or not.
it does take a little bit of time. There's a lot of people sending in questions. So if the question replicates something that's already been submitted and it seems like it is, then they will send it back, you know, and just say to go to this. I mean, I think they're being overwhelmed with a lot of questions at this time.
Yeah, they're at, to be fair, they're at a off-site conference for 2 or 3 days. And we've got the Labor Day weekend coming up, so we'll see.
Yeah, it takes about 2 weeks. I've submitted questions.
I
You know.
submitted a question and they responded with like a question. I'm like, that did not help at all. But maybe it was the way I worded it too, and they didn't know how to answer it. And I was like, okay, I have to redo it. And which is Fran, that question about the designated agency. What happens if I'm the listing agent? I have I have a designated agency with the seller. I'm hosting my own open house because that's part of my job. And I get an unrepresented buyer who wants me to write the offer. Now I can't represent that buyer. The broker refers them to someone else in the office. Do I get a referral? I don't think they want to answer that.
I know. I sent that question in also for you. And
so they responded with the question, which didn't make sense at all. And I'm like, how are you guiding me now?
hey, listen, if you want
What
to,
prevents someone from you teaming up with, what would prevent you from teaming up with somebody in your office that says, hey, listen, I'll handle your designated agencies, you handle my designated agency.
yeah, you can't, you gotta,
you know, I'll give
it's
you $1,000, whatever. We both mutually agree to $1,000.
the broker is supposed to be the one who becomes a neutral party and assigns that. And we can only speak that, you know, we don't really want anything underhanded going on. We would prefer to have it above board, and that's why we're trying to get that answer.
Just be on the record, I am being above board. I'm just saying.
You know, I know. I understand what you're saying. I just, you know, until we get that answer, we really can't give people the right answer. I mean,
designate an agent from a team, like a team leader. Can't have somebody on the team be yeah. So that's why I feel like the referral is out the question, because they don't want the other person. It's pretty much like separating the two, the buyer and the seller, and they have nothing with one another. Like there's no money being exchanged between the listing agent and the buyer's agent. So I think for that, they're not going to allow a referral, but we'll see. We'll see. They keep changing. We're going to see more changes. I don't know, Fran, if it was you or if it was Rob Durso who said that, you know, there's going to be more changes, but now they're going to really wait until the hearing, which is in November, right?
Yeah.
Also,
no,
is it November?
The attorney for the NJMLS spoke to the Real Estate Commission, not to the state, to the Real Estate Commission, who said that they're going to be probably affecting changes, but that is not going to happen. They want the settlement to be done because everybody is still making changes. I don't know, like the New Jersey MLS, we're now removing the seller concession field. And I believe All Jersey, I don't know if Rob is on Dorso, is also, he says it's leading to a lot of confusion with agents. They think it's the compensation and it's not the compensation. So, you know, we have to do what we can, advised by attorneys to legally protect. I'm a director on the NJMLS, to protect our, you know, our MLS. You know, we don't want to get caught. And as Rob said the other day at our leaders management meeting, that, you know, this guy, Michael Ketchmark, is, you know, they're watching everything that's being done. They are just sitting, waiting for mistakes to happen. So we are all being super careful. There are some things we can get like relatively quick answers from state, but I don't want to abuse the right to do that. So we did find out on the cooperating broker to broker compensation. The state has been asked, and I received an email the other day that they're going to be updating that form to, or updating the form or updating cooperating broker to broker for sales and making something for rentals. So it can be used for rentals also, because that seemed to be a big issue. So I was able to get that answer from them pretty quickly. But I can't send special questions to them directly, all the time. But I would advise anybody that's on here that they are taking applications for the state. And if you want to have a voice up there, consider you try joining the risk management committee. And that would be something worth being on, because that's where they talk about all these forms and changes and stuff like that.
Looks like Patrick asked, do we know if you can decline from working with an unrepresented buyer if your seller directs you? Do you have a dual agency or a designated agency?
We don't want to work with an unrepresented buyer. Even if he wants you to, we can't. If they don't want us to represent them, we cannot be the ones. We can tell them they need to contact their attorney for their contract. It doesn't matter what the seller says. You can't go out on a limb and take a chance like that. They don't want representation. They need to get to their attorney to choose how they're going to make their offer. You're more than willing to get the offer in from their attorney to the seller and present everything as you would any other offer.
But are you required to write the offer for them, Fran?
No, New Jersey
buyer
Realtors
agency
said
agreement.
do not write the offer. No.
Yeah, I have to say, I did see the news from NJMLS, and I know maybe for some of our agents here will not apply. I do agree that the whole compensation, like the seller concession and commission, agents were assuming that the concession was a commission automatically, and it's not. There's two separate that goes directly to, it has nothing to do with your commission. I think it was just kind of implied that, hey, if the seller's offering the concession, that's commission. And same thing with Garden State MLS. They had removed the field where they had 3 questions. Is the seller offering a buyer concession, yes or no? And then it had the field, if so, how much? And then is it a percentage or a value, like, an amount? So I do agree that that was really confusing to agents. They thought if they saw 2%, 10,000, they just thought that was the commission. It's not. That goes to the buyer. Another thing I just want to add before we start is with the buyer agency agreement, you're all doing your homework beforehand. You find out if the listing side is offering a commission or a compensation. If they are, it doesn't mean your buyer agency agreement is 0. It has to have a percentage or a value. Whatever you have on that agreement, that's what you're getting paid. So if the sellers are offering 2% commission, and now you're like, okay, the seller's paying me, you're not going to put 0 on your buyer agency agreement. You must put the 2%. Okay, so I know I've gotten a lot of questions, Fran. I don't know if you had any questions like that, but you can just, on the 3rd page of the buyer agency agreement, just check mark that the buyer wants you to submit offer where the seller's offering the commission. There's so many different ways, but don't put 0, because then you're making 0. If you put $1, you're getting paid $1.
Was there anyone here that did sign up for the rental compliance? Because, it's the week before Labor Day. So that's why I think the attendance is very low, because we've been getting like 89, 90 people on Tuesdays.
Yeah, I feel like today, I wanted to give you guys the option. I know a lot of you took my rental compliance because I see the names. Would you guys want to go over like the buyer agency agreement, the cooperating broker agreement, listing agreements, or would you like me to go over the rental compliance? Since it's a short, small group, I'll give you guys the option. Either one, we're prepared.
Rental, please.
Okay. Anyone else?
Rental.
Rental.
Okay. So I'm going to share my screen. I have to say, so this presentation was prepared by Fran Blakely. Thank God she's on, because if I don't do a good job, she'll be here to make sure that I give you guys the right information. So this is our agenda. It's 4 sections. So we're going to go over the Fair Housing Act, New Jersey Fair Housing Laws, Code of Ethics, NAR Education, the ADA. Section 2 will be the lead paint disclosure, lead paint certification, municipality list. Section 3 would be the flood risk notices, and Section 4 will be compliance and dot loop. So I know rentals may, they were very easy. They're still easy, right? You can close couple a month, couple a week. However, we have to make sure that we're following the law. We've been doing a lot of rentals recently, but we've also been getting a lot of potential threats of lawsuits because of them. Sometimes it's not us, but it's our clients. So we have to make sure that when you're taking those listings, you make sure that the owner of the property is aware of all these laws, and you know, it's not going to be an easy rental. All right, so I'm going to just read this out loud. I know you guys can all read it, but sometimes hearing someone else read it, it will probably click. The Fair Housing Act protects home buyers from discrimination as they get a mortgage, rent a home, buy a home, seeking home housing assistance, or participate in other housing related activities. The Fair Housing Act prevents discrimination based on color, sex, national origin, religion, disability, or familial status. So here's the NAR Code of Ethics. On November 13, 2020, NAR Board of Directors strengthened realtors' commitment to upholding fair housing ideals, approving a series of recommendations from NAR's Professional Standard Committee that extend the application of Article 10 of the Code of Ethics to discriminatory speech and conduct outside of members' real estate practices, which means as realtors, you are held to a higher standard. So like I said earlier in the beginning, we come with the law. So Federal Fair Housing Act, what does it cover? The Federal Fair Housing Act prohibits discrimination in housing on basis of race and color, national origin, religion, sex, familial status, and disability. It is illegal to discriminate against persons belonging to any of the, hold on, let me just remove, of the above listed legally protected classes in any of the following situations. So refusing to rent or sell housing to any person who is legally protected by the Act, setting different terms, conditions, or privileges for a sale or rental to any person who is legally protected by the Act, providing different housing services or facilities to any person who is legally protected by the Act, falsely denying that housing is available for inspection, sale, or rental to any person who is legally protected by the Act, refusal to make reasonable accommodations in rules or services for a disabled person that have been deemed necessary by a physician, refusal to allow a disabled person to make reasonable accommodation to his or her dwelling, threatening or interfering with anyone making a fair housing complaint. So I'm not just going to read, I'm going to just go over it a little bit. A lot of it, you know, it's based on how you take the listing too. I'm going to start off with Section 8, right? It's very important that when, obviously, in some of the owners' minds, Section 8 is not good, right? They think that somebody's gonna take the property and not pay the rent. But a lot of times, you know, they have different vouchers, right? It covers the full rent. And think about it. Do you really think somebody who is on Section 8 will try and ruin that for themselves? And, you know, they have people they're working with, so they're not going to want to ruin that income that they get for their housing. So I know you guys had some questions like, okay, if somebody's on Section 8 and you have somebody who's contacting you that they're like, hey, I'm a Section 8, does your client take Section 8? Or do you take Section 8? They usually don't say if the owner, they ask you, do you take Section 8? Your response is always under, no matter what, yes, the owner accepts Section 8. Okay? It's always a yes. I know there is some housing where, you know, they don't take Section 8. It's not, you are not going to say no to anyone that calls you about Section 8. You have to be careful because we do have testers, especially now. I heard from another manager, there was 20 testers that were hired for Bergen County. If you have a rental, you're going to get calls about Section 8 and they may be testers. You might get a call from a Section 8 tester, and you're going to get a call that somebody who has like an 800 credit score that makes $150,000 applying for a $2,500 rental. You have to treat them the same. If somebody's messaging you saying, show me a I'm a Section 8, and now you kind of ignore them because you want to focus on this person who has a perfect credit score, you're putting yourself in a position to get a lawsuit. Make sure you show it to both. How are you going to guide your owner is make sure you post everything on your listing. For example, 650 credit score or more. Last month bank statement, last year tax returns, photo ID, proof of income. You can't pick and choose. You can't tell the Section 8, oh, well, you're a Section 8, the owner wants to see 2 months of worth of bank statement. Meanwhile, the person that's not a Section 8, you only ask one. It has to be the same. The best way to cover yourself, if it's in writing in your listing, that's it. Now you're protected. No one can say you're choosing between one or the other. You submit everything to the owner and it's up to them. A lot of times Section 8, they might have a voucher for a specific county, a specific home, a specific amount, right? A lot of times it covers 100%. Sometimes it covers 70, 30. It doesn't mean that they are prevented from being able to rent a home. I remember during COVID, I'm sure a lot of you do, most of landlords that got paid during COVID is from Section 8 because the state never stopped those payments. They were still getting paid. I think what prevents owners from accepting a Section 8 is because there is an inspection being done before the person moves in. Now, regarding a refusal of making reasonable accommodations. So obviously if somebody has a disability and they request that the owner does some type of modification, it's going to be on the tenant's expense, but the owner must provide it. Fran, if you want to add anything to that, please do.
Okay, if it's outside in a common public area that the accommodation needs to be done, then I'm not sure that the tenant has to pay for it. But if it's inside the unit, I think there's a difference.
Yes.
And each case would be weighted separately. We'd have to really look into it and just say, I mean, if they're asking for something that is not extraordinary, like they need a ramp for like steps or need a doorway widened to fit a wheelchair, those are things that, landlord, they're reasonable accommodations, right? Unless you're hitting the main beam of the house and you can't widen the doorway or something extraordinary comes up. But you want to be careful, and you do have to make accommodations as long as they are qualified to rent the place. Yeah.
And again, we come with the law, so we don't deny anyone. If an owner refuses to do any of what we discussed, you have to withdraw the listing. You don't want to risk your whole license and fines and lawsuits even if it was $10,000 rental, it's not worth it. So I always get questions like, oh, but my client doesn't want to take Section 8. Release the listing immediately. That's how you're going to get yourself covered. You do not want to be part of it. We've heard it all. We've seen where, our agent was just trying to do the right thing and they're the one who is dragged to the lawsuit because they were just saying, oh, I was just doing what my owner wanted me to do. You come at the law, make sure you follow the law.
Right. And then when we get to New Jersey laws regarding discrimination, they go even further than the 6 protected classes that we have on the federal.
Yep, which is coming up next. Yeah, so New Jersey's even more. It's pro-tenant, and we just have to make sure that this is just a refresher for all of us so that you guys are aware. So again, federal fair housing law prohibits discrimination in housing to 6 protected classes. However, New Jersey extend beyond the 6, which we'll go on to the next. So here's in New Jersey, it is illegal to discriminate against a prospective or current buyer or tenant because of race, creed, color, national origin, sex, gender identity or expression, marital status, civil union status, affectional or sexual orientation, familiar status, pregnancy or breastfeeding, actual or perceived physical or mental disability, ancestry, nationality, domestic partner status, source of lawful income used for mortgage or rental payments, or liability for service in the armed forces of the United States. It is also legal to place any advertisement or make any statements or utterance that express directly or indirectly any limitations to offer housing or real estate based on any of those characteristics. The list goes on.
It sure does, you know. And also, you know, Donna, I don't think we have it up in .loop yet, but I'm not sure. There is a new Truth in Renting book, which I emailed you just recently. So that
Yes,
is
it's
out.
being uploaded from
Yeah.
.loop. It should be up by tomorrow. So yes, that will be replaced because it has been updated. So you guys need to get, your client just needs to initial just at the bottom last page. So that way they know we can say that they have a copy of it. All right.
We kind of went over that already, right? The
We did.
reasonable.
Yep.
Yeah.
We already did this. So I'm going to skip this. Unless you guys have any questions, please feel free to speak up. This is our time. There's no right or wrong questions. It's only wrong if you don't ask. All right, so here are some examples. If a tenant with a disability has special needs that require making an exception to an existing policy, such as allowing a seeing eye dog in a building with a no pet policy, the animal must be allowed and an additional fee cannot be charged as pet rent or as an additional security deposit because assistant and service animals are not considered pets. There are reasonable accommodations necessary for tenants with disabilities to enjoy the premises to the same degree as tenants without disabilities. This is a big one because a lot of people have pets, emotional, service animals. So you guys always come up with these type of examples. So now you guys know your landlord cannot request additional rent or security for a service animal. Another one, for example, if one of your tenants becomes disabled in an accident and needs to use a wheelchair, you may have to take steps to provide or permit reasonable accommodation or modification. The tenant may request that you add a wheelchair ramp to the building so they can enter, use, and enjoy the building to the same degree as tenants without disabilities. If the ramp is to allow access to a public space, such as an office, the pool, the gym, or the garage, your duty to provide reasonable accommodation would likely give rise to an obligation to add a ramp. So Fran mentioned that, so she was correct. Failure to install the ramp could expose you to liability under federal and state law because in this example, the ramp is a public space. You may be responsible for the cost to construct and install the ramp. The same is not true with respect to access to the unit itself or the inside of the unit itself. Fran has this memorized. That's why she knew this. She knew it was coming up. As a landlord, you may not charge a tenant requiring a reasonable modification an additional fee for implementing the reasonable modification, nor can you require a larger security deposit based on the tenant's requested modification or medical equipment. For example, if a tenant requires that a wheelchair ramp be installed in his or her apartment, you may send him/her an invoice for the cost of installation. Or the tenant may arrange for construction of the landlord-approved ramp at the tenant's own expense, but you cannot charge a fee over and above the cost of installation, nor can you require a larger security deposit based on the modification or, in the above example, wear and tear from the tenant using a wheelchair in the apartment. Do you guys have any questions on this? So everybody understands what this means, right? The owner of the property cannot charge the tenant more for, they can't say, oh, for the inconvenience, or I had to hire somebody. They can only charge for the exact amount that they were charged. So I just want to make sure you guys all understand that. You cannot try and request, you know, the tenants sometimes I've seen it, they're so desperate to get an apartment or housing that they will tell you like, oh, I'll pay more security. Just remember the owner cannot collect more than what, you know, if it's a month or a month and a half, whatever they're collecting, they can't charge more for this type of accommodation.
The other, you know, Dawn, I just want to add one thing on a recent experience. If there is an interview required to
Yes.
make sure everything is clear as to the special needs of the person renting and whether or not something is reasonable or not reasonable. You cannot, you know, extraordinary circumstances, the owner's away, can't meet the tenant for another week. You cannot get your commission paid to you. You need to do all the diligence first. If the interview is required to really determine if this tenant is 100% acceptable, no matter what, you must do that interview and have the tenant and have the landlord accept the tenant officially for everything. You just cannot say, oh, well, I'm going to deposit the commission check because the tenant's given the checks and then I'm going to have the interview. And then the landlord turns around and for some reason decides that this is not acceptable, whatever it is, or it's way beyond a reasonable accommodation of some kind. So it's nice to get paid, right? It really is, but it's a lot to give back that money if things don't work out. So just keep that in mind, okay? Get everything done that's required for this interview.
Thank you for sharing that. Do you guys have any questions? It's like no one's gonna want to do rentals after this, Fran. I think
I know.
You're off. They're
This
like,
is-
forget this.
This is a fun thing to do. When you have the time, you'll be surprised at some things that you might answer that you would not think you're up to date on fair housing after you go through it. It's a free simulation. It's called Fairhaven from NAR. And it's definitely worth doing it. It kind of is a reminder of everything that you're supposed to do. And I took it a few years ago. So it's just an online simulation training and it's free. And consider trying it. It's a good reminder of, oops, I can say that. Oops, I can't say that. Oops, that's the wrong answer, you know. So it's a lot of, it's interesting, definitely interesting. Well, this is another one. This one is, I went to a seminar on, but NAR has a bias overcoming barriers to fair housing. And it's things that you don't think that you say in your everyday life that you have an implicit bias in your mind about things, you know, like it's just because maybe that's just all you've known and how you've grown up or whatever. And overcoming those barriers is really, really difficult. So this is another little class that you can take at NAR and go through education and take it. It's just worth it. You know, if you have like in the winter, if you get a snow day and you're stuck at home, take the time to look at some of these things. They're very valuable and good reminders.
In New York, Fran Tack is on. She can confirm we're required to do 2 CE classes for bias. So like when I'm completing my CE classes, this is a requirement. I won't be surprised if this doesn't become, you know, a requirement here as well.
One class after another. This certification is really good at Home with Diversity. I did this during COVID, you know, when I was home. Teaches you how to conduct your business with sensitivity to client profiles and build a business plan to successfully serve them. So you want to make sure, and even if you're doing your own social media, that you don't realize, you know, you can't post the same type of people in your social media posts. You have to diversify. You have to, you know, be really careful about making sure you're being fair to all people. So you're encouraging everyone that you want to do business with them. You don't want to just start eliminating people based on you know, who they are or what they do. And, you know, I'm sure everyone's had this experience. I've had it many times with my husband because he's a pain in the neck with this, but we used to go out to shop for TV or shop for something. And, you know, or a car, and he would look like the sloppiest he could. And, you know, it's like, it's amazing the way people treat you differently by your appearance, but you have to treat everybody fairly. You have to be fair to everyone. So this is also a great class to take.
Like one of them would be you representing one type of culture and saying, oh, I just helped my first time Albanian clients close on this. It's, you know, you obviously don't mean to discriminate against anyone, but somebody else could see that as, you know, being biased. And
Right.
my favorite, lead paint, base paint certification and disclosure, contract of sale and lease, reminder, lead-based paint disclosure for sales and rentals are required for all properties built prior to 1978, must be completely filled out. Failure to do could result in $11,000 fine. I really think the state is really trying, like Fran said, trying to find mistakes too, right? The real estate commission. So I've seen reviewing some files where you're trying to do this quickly, right? You're trying to get as many listings as possible. It's an oversight where the lead paint, where the owner has to check mark one of the boxes. Now, most of them, it's either they have the report or they don't. You have to check mark one of them. Excuse me 1 second. They're doing a test in my home. I'm gonna pause. Fran, can you just discuss this? Oh, it's stopped.
Sure.
Of course, today they're doing a sprinkler testing in my home.
Oh, hopefully
So
you don't have a rain shower coming down soon.
I hope not.
But this is federal. Everybody should know. Oh my God, I just lost my voice for a second. This is federal. And for every missing initial, it's either $2,000 or $3,000, and it's up to an $11,000 total fine for not having this form completed properly. I didn't even realize that it was $2,000 or $3,000 for an initial being missing until I had to ask another manager of an office to have her agent. She was refusing to have the buyer initial one part of the bottom part, saying that they received copies of above. It's just like, that's why it's important that when you're doing your lead paint form, that you're getting a completed section on the top from the seller and the listing agent. Don't fill out the bottom with your offer and nothing is filled out on the top, because you really can't do that. It says the first question under Roman numeral 6 or line 44 is leasing has received copies of all the information listed in section 3 above. Well, you can't provide and have them initial something that they haven't received yet. You have to make sure you're getting it fully completed from the seller first.
I'm just gonna mute myself. Hold on 1 second.
Go ahead, you pick up, Adona. Sorry, you're muted. You want me to finish, or
you finish it because the alarm keeps going off. It's really annoying. I'm gonna mute myself.
Okay.
I'm here.
Okay, so you want to make sure that each on the section A, the seller is checking off one of the 2 boxes. Section B, one of the 2 boxes. And section 3 means that in the event that they become informed that there is lead paint in the apartment or house, that they will disclose it. And then they sign it, you sign it as the listing agent. Now on the other end, again, they have to sign initial A, B, and there was I thought there was a C. Oh, go back. 56, no, okay. So then the tenant has to sign it and the tenant's agent has to sign it. If you're representing both parties, you have to sign it. Now on the next slide, in addition to having this form completed, New Jersey in rentals, as we're going back to rentals, wants all rental dwelling units need to be, and instead of inspected, that should say certified for lead-based paint. There's a difference between an inspection and a certification. This was put up by the Division of Community Affairs. And what has to happen is some of the towns have these lead paint inspectors who do the certifications and some don't. If the town does not include it as part of their CO or CCO, then the seller or landlord is still responsible for hiring someone to come in to do this certification. Down below is a link that gives you all the municipalities in New Jersey and will tell you what type of certification is needed. Some of them just have to be a visual and some have to be dust wipe. Depends on the county and the town where you are. And that was developed based on the number of lead-based paint cases that came up with children in those areas. It has to do, I'm sure, with the age of the housing and everything else. So number one, when you get a rental listing and it's before 1978, check, do the lead-based paint form, check this list, let your landlord know that they will need to have a visual or a dust wipe inspection. You could call the town for them, or you could direct them to the town to see if the town does the certification. But if not, you need to supply them with the name of someone who will come in and do it. And they not only look at the inside, but they look at the outside of the property also. So that's what you need to do. You need to get them prepared. If they don't touch up, they're looking for chipping lead paint. If they don't touch it up, they're going to have it fixed by a lead paint certified painter. Okay. And that is like triple the cost of money to get it fixed than having it just, you know, cleaned up before someone comes. And I'm not saying that you're hiding anything, but you don't know when the place was painted. You don't know, you don't want anyone to get sick. We had a case like this. I know of a case like this in Morristown where someone was renting a unit and the child got very sick from lead-based paint before all these laws came into effect. So you have to be really careful about it. Okay, are you finished with your buzzing?
For now, yes. If it goes
Okay.
off, I'll pause and then you take over.
Okay.
All right. I forgot that it was today. Anyways,
You can talk about this. Go ahead.
of course,
You're on mute.
it keeps going off, so I keep muting myself. Okay,
Oh.
so you just went over this, right?
No, you got to go to the flood risk. You got to go back. There you go. Flood risk notice. Oh, we did this.
This
So
one.
now, this one.
Yeah.
Mhm.
All right, so the flood risk rentals, it's so important because a lot of you are questioning this. This is a new form. It's by law. This is not a Remax form. This is a New Jersey form that needs to be completely filled out. As you can see for question 1 and 2, there is not a known. You must guide the owner. They can check the FEMA's website, tax records, whether or not the property is in a flood zone. The third question can be unknown. Of course, like right now it's happening. Give me 1 second.
Okay, so the flood risk notice, it has to be completed and
Right.
given to the tenant, right? If you don't know, if your landlord is not sure, you know, the flood maps have changed significantly in the past few years due to many of the storms and things that we've had. But they do know, you know, basically if they've been renting the house out, also if there is, you know, water that generally like pools in the driveway or any other kind of, you know, water in the property during heavy rain or something that may happen. So you technically have to look at the flood maps or give them direction to go to the FEMA website to check it. It takes less than 2 minutes if you get the right website to submit and find and let them read the determination. They can get the report and decide if it's in a flood zone or not. And then they should be able to answer the rest of the questions. Okay. As you go to the next form, so it's definitely, this is required with every rental property. In here, in your residential lease, it states about the lead paint, you know, that the tenant acknowledges receipt of the EPA booklet, so that you're giving them the booklet on lead paint, protect your family from lead in your home. So they're acknowledging that in this lease that they're signing. And it's your duty and responsibility to go over these different things with your tenants, because they are not educated as you are with all of this. Also in here is the landlord acknowledges that effective July 22nd. So when they sign this lease from 2022 on, that any units built before 1978 required to be inspected prior to the New Jersey lead paint inspection law, which is having the lead paint certification. So you're certifying, or they're certifying, that this is being done. You know, this is like serious stuff. What are the consequences? I couldn't answer that for you. I don't know the answer to that. I don't know if they have started penalizing people for not having this done, but you need to give your informed consent to them to get these things taken care of. And the next one, the reason I put that in there, in a contract of sale, the reason why you want to bring these, it states in the contract of sale that this property, should they choose to rent it, would be subject to having a lead-based paint certification on the rental turnovers. Somewhere in there, I'm surmising, okay, somewhere in there, it says that, because if you're party purchasing a property all of a sudden says, oh, I don't want to live here anymore, but I'm going to keep it, I'm going to rent it out, and they come to you and they're like, what do you mean I have the certification? You never told me that if I decide to rent it, that I was going to have it certified. Well, you have to just bring it to their attention. You know, you have to make sure that they're being told, as you should, in reviewing the contract with them, so that they are informed. This is all about informing the consumer and transparency. Questions? Ask Adona.
Yeah, right. So you just went over this. Disclosure that property may need lead paint certification on contract of sale. I think this is what you were just talking about.
Right.
Dwelling inspection. All right, so dot loop. Creating your loop, go to all Remax select documents.
Did that change?
It's gonna change as of hopefully Friday or early next week. So for now, it's going to be what you're seeing on the screen. So I'm not going to show you what it's going to look like until it's done. We'll do more trainings. So you guys will have, it will be easier for you guys to access these forms. For now, when you go and select the rental listing, pick the landlord, all the required documents will be marked required. What does that mean? If it says required, it's required. There's no exceptions. Okay. The only exception you'll have is if you're listing a property that was built after 1978, and then you don't need the lead paint. Other than that, if it says required, it's required. When you're preparing a lease, pick the tenant, and all the required documents will be marked required. Secure the landlord flood risk notice for tenant and lead paint disclosure from listing agent. Now, if somebody is not doing their part, let's say you represent the tenant and the listing agent did not provide you with the flood risk notice or the lead paint disclosure, it's still your responsibility to make sure you take that before your client signs the lease. Get that documents from the other side. I know some companies, they say, oh, they're not complying. It's the law. The moment you tell one of us, the managers, we reach out to the broker, we'll make sure we get that form. It's a law. They need to provide that. There's no exceptions to any of the required documents. So just remember, you're not opted out from responsibility if the other side did not provide you one of the forms. It's your job to remember that you need the flood risk, you need the lead paint disclosure, and then make sure the lead paint booklet must be provided to landlord and tenant. Okay, so don't forget that has to be included. We have about like a few minutes to spare if you guys have any questions that you guys would like to ask.
I have a question. Okay, it has nothing to do with pertaining to what we just discussed. The tricentennial ethics course, that is separate from the ethics that we take for continuing ed, right?
It can be part of it. I think you can work that into. your continuing education.
Oh, it could be. Are you sure? Oh, only because someone had taken ethics, but they didn't get they took a specific one for ethics, and it wasn't credited to their continuing ed.
Well, they have to take the specific one that's required by NAR.
Okay.
And
So as
if
long
they can
as
find that one where you get credit for it, you should be able to use it for both. But unless I'm
Okay, so
wrong,
the-
I'm not sure.
Okay, so the NAR one would give them credit toward the continuing ed, as long as they took that specific one. Okay,
Yeah.
all right. Thank you.
Mhm.
You guys have any questions on rentals? Charles,
it-
did you ask all your questions? I know you said you had a few questions.
Yeah, I'll save it. I can send you a courtesy copy or to Rob of the questions I'm sending to NJAR because people may have similar questions. For example, just one of several. One is this, if the seller's providing, say, 2.5% commission, your buyer's agency agreement says they'll provide 2.5% commission, then which one rules and who pays?
That the seller can pay. If the seller's offering 2.5% compensation and you have an agreement for 2.5%, you're taking it from the seller.
Is that a rule, a law, or could they change their agreement retrospectively and say, well,
yeah, you could
Just a-
handle it like two different ways. I mean, if you can get your tenant to agree that you're accepting 2.5% from the landlord and from the seller and 2.5% for them, that would be
Can't get-
like a win-win, but chances are they're probably
No,
not
no.
gonna do that.
that's not what I'm saying. You can only
Yeah.
get it from one part. But what I'm saying is if you have two contracts, right, two agreements, it's weird if you think about it. So which one supersedes the other?
So Charles, you just said you can't get from both. You can actually now, they changed it.
Yeah.
You can get paid
Those
both by buyer and seller. So for example, if your agreement was 3 and the seller was offering 2, you can take 2 from the seller, 1%, just an example from the buyer. But now if you're saying if the seller's off, if your commission is 2.5 and the seller's offering 2.5, then you can make it's negotiable, right? If you want to get your client that property, you can say to your buyer, hey, look, if you can afford the 2.5 and you want to collect it from the buyer and tell the seller, hey, look, this is my offer, but my buyer's going to pay me my commission.
Mhm.
There's no law that's going to say which one is more, which one, you know what I mean?
Yeah,
Like
yeah. I just find the whole thing very interesting in terms of how they structured this. I mean, bottom line is everything is negotiable up to the last minute, essentially. But there are certain things that you can't violate. Like it was interesting when I sent my questions to NJAR, they sent me 4 documents, all of which I had previously read, and they conflicted. Two of the pages conflicted with each other. So I'm sending it back to them and saying, okay, this is what you said on this page, and now you said this on the other page. They conflict. It's just a very interesting, the different scenarios that one can come up with. It's not always very clear. That's all I'm saying.
Yeah, send me those questions to Rob and then I'll have Rob forward it to me. And when you find answers, I would love to see what
Oh, I
those-
love to. Yeah, I'll
Yeah.
definitely.
Yeah, so
And of course, you can always revise your buyer's agency agreement at any time.
correct.
So you could change that since the seller's offering 2%, you could go back and revise it to 0% in case, and you don't have to show it to the seller's agent, right? They can ask for it, but you're not required to show it.
They're not. The only ones that would probably be the attorney maybe, but other than that, if it was questionable, but no one, if I've seen a listing on Facebook this morning where somebody it's not from our state, by the way, but they had said, oh, if you're scheduling a showing, buyer's agent must provide a copy of the buyer agency agreement. Not allowed. Like you don't have to share that with the listing agent.
Right. Yep.
And I'm suggesting, because on the contract of sale has been revised, you can obviously now write on both columns, like if you're getting paid by both or one or the other. If you're getting paid by the seller, make sure you get the cooperating broker agreement, just to make sure that you are covered, you're getting your percentage.
Yeah, so I'll go back to just made a few minutes ago about being able to receive compensation from the two sides, but that's really only under disclosed dual agency. The old rule of not being able to accept from both parties supposedly still exists. So what was interesting,
It doesn't.
Mhm.
It does not. You can actually get paid by both. If I have a buyer that's agreed to pay me 2.5, and
Right.
I find them a property and the seller's only offering 2, I can take the 2 from the seller and I'm gonna ask my client to pay me the 0.5%. It doesn't have to be a dual agent.
Right. So I can show you the document that NJAR sent me. And it says in the spirit of or not in the spirit, but according to the NAR settlement agreement, you are not to take the difference between the two in the event where the seller's providing more compensation, let's say 3%, and the buyer's agency is 2.5%. They're actually saying that you can only collect 2.5%, and you have to give 0.5% back to the buyer. But if I were the seller, I have a contractual arrangement with my listing agent to give 3% to the seller. It does not say, I don't think, in the listing agreement that if it exceeds, then the seller must give any difference to the buyer.
So,
it's very
I understand what you're saying. So there's 2 different things that you're asking. Now, you can get paid by both if your buyer agency agreement was more than what the seller's offering. Vice versa, if the seller was offering 3, for example, to just make it easy, and the buyer agency is only 2, you can only collect 2. I do see that, and I did also question that, where on the listing agreement, the seller can say if there's overage, they can keep the extra percent or whatever it is, or they can offer it to the buyers for the buyer's closing cost. Where on the buyer agency agreement, the buyer says, it is, you're not going to see a lot of it. Let's just say that, because the buyer agency agreement, you can amend it, right? So you can have a conversation with your buyer saying, look, I will agree to the lower 2%. However, I want to make sure that we are both in the agreement. In the event I find you a property where the seller is offering more, I can amend my agreement to collect the amount that they're offering. As of right now, it's allowed. Why are we putting ourselves in a position for them to make that change? It's negotiable. You can you choose what you want to get paid. If the seller's offering just 2, but you deserve 3, you tell your buyer to pay you the extra percent.
Right. I agree.
That's what we wanted all the time. We wanted to do that.
I think that's the purpose of the whole Section 17, right? You can craft it if you really want to, as long as you can negotiate buyer. It's just that some of the language from the NJAR is conflicting. Like they'll say in a certain part, like I said before, that the only time that you can receive compensation from both sides is during a disclosed dual agency role. It doesn't say or you can negotiate separately in a non-disclosed dual agency role to be able to accept commission from both sides. See what I'm saying?
Well, I'm not sure, because that has changed. We are allowed to get paid by both, not just because we asked that question many times.
Okay.
And it doesn't have to just be a dual agent. If I have an agreement with my buyer for 3, the seller's offering 2, my buyer is going to be okay with paying me the extra 1. I'm going to collect from both. Nothing as of right now. That's what we're telling our agents. I don't want them to be confused until we're told otherwise. They can get paid by both. I fully support it. I'm sure Fran does, and all the other managers here. We're not telling them to do something that's not with the law. Like, we were not advised differently until they come up with something saying, oh, wait a second, no, you cannot. That will be different. But I would just tell you, don't question something. If you're allowed to do it, do it. Know, they did this to make us, they think we make a lot of money. Well, let's show them now we can actually make more money, because I can negotiate my deal with my buyer, negotiate with the seller, and you probably end up making more than what you did before.
Oh, I agree 1,000%. I love this. I think it's great, personally.
Yeah. So when you love something, don't question it to change it for everybody until they figure it out themselves. I mean, nothing is stopping us from negotiate your deal. Like, this is your time. Go ahead, go get listings, go get buyers, feel confident. I guess because I've been doing so many of this trainings, I was able to get 3 of my close family friends to sign a buyer agency agreement. And those are actually harder than just somebody that's not family. Because, you know, they're like, why am I signing an agreement with you? You know me, you know, I'm going to pay.
Mhm.
So just be confident.
Yep, absolutely.
Discount yourself. You know, it's negotiable. Don't try and discount yourself. Just show your value, why you're worth it.
I gotta
1000%.
go.
Yep, it's 11 o'clock. I'm gonna end it here. Just remember, guys, what's today's date? Today's Tuesday. We do have a 6 p.m. questions and answers from Fran Tack. She'll be on tonight. So if you guys have any questions, she's laughing. I don't know why.
And tomorrow Marilyn is doing the 10 o'clock because I did
Yeah,
Monday.
Maryland will be
so.
10. Thursday I have to find coverage because I do have an event to go to, but it will be at 6 to 6:30. So if you guys have any questions, feel free. Next Tuesday, I do have some in-person trainings for my offices. I might just go over again some of the new documents. I want to probably at that time I'll have dot loop ready for you guys, so I'll just do a quick rundown of what it looks like. It's going to be, you know, it's not going to be a 1-day project, but I promise you we're making a lot of progress. The documents are not integrated, so it should be easier for all of you, and I appreciate you guys joining today. I know it's a holiday week. I hope you guys have a great week. Go make money. And we're here to help you guys, anything you have. Take care.